Absolutely.
Thank you.
Mr. Gary Mendez? Ms. Canchola?
Present.
Trustee Rodriguez Moisa?
Here.
Trustee Castaneda Calleros?
Present.
Trustee Lopez?
Okay. Trustee Castañeda Calleros, would you like to give us the honor?
Yes, it would be my honor.
Please stand and face the flag. Join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yeah. Okay.
Like me to do the land
Yes, I was
acknowledgement?
just going to ask you.
Absolutely.
Thank you.
The Whittier Union High School District acknowledges our presence in the traditional ancestral lands of the Gabrielino Tongva peoples, which includes the villages of Chokishna, now Santa Fe Springs, Sihate, now Los Nietos, Whittier, and the village of Sijitna, now Whittier San Gabriel River area. This land remains unceded territory. Whittier Union High School District honors and respects the Gabrielino Tongva ancestors and their connection to this land.
Thank you. So I would like us to now consider the approval of the minutes from December the 2nd, which was the special board meeting.
So moved.
Second?
It's been moved in second. All those in favor?
Aye.
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 All right, we have the approval of the minutes have happened. So we go to the approval of the agenda. We would like to consider approval of the December 9th, 2024 special board meeting.
I'll move approval of the agenda.
I'll second the motion.
Motion and a second. All those in favor?
Aye.
Okay. Dr. Oviedo, do we have any community comments?
We do have a community comment I think Mr. Gallagher would like to read.
That is correct. So with the board's permission, I received a communication from President Mendez asking that the following be read under the public comment section of tonight's meeting.
Excuse me, can you make sure your mics are turned on? There's a little green light.
Thank you. Let me repeat what I said. So board members, I received a communication from the board president asking that the following be read during the public comment sections of the meeting. I will read it verbatim and then give a copy to Olga so she has the exact writing that I received. Board Policy 9322 prohibits agending non-district subjects, in regards to the special meeting held December 9, 2024. This meeting violated BP 9322. Quote, items not within the subject matter jurisdiction of the board may not be placed on the agenda, period, end quote. A political communication by CSEA, a union organizing message, was sent to its membership through an external network, is not the subject matter jurisdiction of the board. I'm sorry, that was within quotes, subject matter jurisdiction of the board. You are responding to an external union political communication. Your action is interfering with the union's right to organize. This meeting should not be occurring. The board wrongfully wants to discuss and respond to a union political communication as the, quote, district, end quote. The meeting which the CSEA union was summoned to attend under duress and was meant to intimidate, harass, and bully, period. The board has no subject matter jurisdiction and will be exposing the district to litigation by interfering with a political /organizing action protected by state and federal law, period. Gary G. Mendez, Governing Board Member, Whittier Union High School District, representing Area 5, South Whittier, Santa Fe Springs, and North Norwalk. And that concludes the correspondence submitted.
Thank you so much. Any other public comments? Okay, so we'll go to 6.01, the discussion and response to the letter dated November 8, 2024 from Trustee Mendez to Whittier Union High School District regarding the Alf M. Brown Act compliance. So we have an opportunity to discuss a possible response. I would like to open up to my fellow trustees. Can I start with you? Trustee Rodriguez Mesa?
Yes, thank you so much, Ms. Conchola. I see we're being recorded on the camera, so I'm actually very grateful for that. Thank you so much for that to the CSEA membership. I want to start off with what I believe to be the appropriate legal framework to look at this situation and a very brief summary of the facts. We received, that is the board via superintendent and the general counsel, a complaint from trustee Mendez alleging a violation of the Brown Act. His letter was sent on November 8 and requested that we respond, that is the district respond, within 7 days, or quote, I must forward this to the district attorney's office. This was a request for us to act. It was not a request for an inquiry, and it only provided 7 days. Unfortunately, I believe that this provision of his request is consistent with trustee Mendez's rush to judgment as opposed to affording due process or an inquiry into allegations.
Madam, if I may, without interrupting, anticipating if I was to project what Mr. Mendez would try to say if he were here, and not to do so, but if you could try to refer to all members of the board by their title and avoid their name, you would therefore avoid any implication that Robert's rules was somehow not being followed, which is incorporated by the board rules. Very typical, I think, for the whole board to refer to each other by name, but I think it's helpful, and when Mr. Board President is here, I will advise him of the same, but I thought there was a reference by name, so I think it may be helpful to insert Board President any place that name would be used.
Wherever I would refer to that, I'll do my best. No
Thank you.
promises.
Understood.
I also understand that when I looked at Mr. Mendez's complaint, he actually writes in the complaint that he wants the board to acknowledge the violation and cure it so we can go back to the business of the district. This request appears to be consistent with Board Policy 9323.2, which does describe a process by which, if there is a complaint regarding the Brown Act violation, the options that the district can take. And it does reference cure or correct the challenged action and inform the demanding party in writing of its actions, and or determine not to cure or correct the alleged violation, or third, take no action. And so today, in this particular item of the agenda, we are here to discuss what the response should be to the complaint and to the requested cure that was listed therein. I want to state first and foremost that it is my opinion and my position that there was no Brown Act violation. And the reason for that is that there was in fact no board meeting as defined by the Brown Act under Government Code Section 54952.2. We all recognize as elected officials that we are governed by the Brown Act and seek to protect and promote the interests of the Brown Act to ensure that the business of our governing board is conducted in public and with full transparency. The Brown Act defines a meeting as any congregation of a majority of the legislative body to, quote, discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the legislative body. That's Government Code Sections 54952.2, subsections A and B. The Brown Act does not prohibit a majority of the board from meeting together at a conference or a purely social or ceremonial occasion, so long as the members do not discuss amongst themselves business of a specific nature that is within the subject matter jurisdiction of the legislative body of the local agency. Again, reference to California Government Code Section 54952.2, subsection C6. Here, the subject matter of the Zoom with the CSEA representatives was to address a political hit piece that CSEA had sent that had been authored by board member Gary Mendez. There was no discussion of any business of a specific nature that was within the subject matter jurisdiction of the board. Moreover, The Brown Act does not prohibit us as individual board members to, in fact, assert our own rights to free speech and to address political attacks. Here, on the evening of October 8, 2024, CSEA circulated a text to its membership that was signed by Mr. Mendez. It is my understanding that CSEA sent the message to its members via a portal they call the Action Network. By sending Mr. Mendez's letter on this portal, it appeared that the letter was on CSEA letterhead. After seeing a copy of this text message, I personally called Art Segrist, the president of the CSEA, and asked to speak with him about the text that had been sent out. He texted me later that evening on October 9 after 8 o'clock and telling me that it was after 8 o'clock and that he would call me the next day on October 10. On the morning of October 10, Mr. Segrist sent me a Zoom invite for a meeting at 1 p.m. I think there was a suggestion in some of the comments that somehow CSEA was summoned to a meeting. That is completely untrue. Mr. Segrist is the one who hosted the Zoom message in response to obviously a request to talk with him. I want to assure the public and all of our district stakeholders that there was no Brown Act violation. We did not discuss any business that's within the subject matter jurisdiction of the board. But to ensure that the public and the stakeholders know that no district business was discussed, I will be requesting, after hearing from my colleagues, that we go ahead and cure the alleged violation by reconstructing that meeting and re-asking the request that was submitted in an email that I sent. I want to set forth that this complaint really has no merit. And in fact, Board Member Mendez knows that there's no Brown Act violation, but he still sent his letter. How do I know this? Well, last Wednesday afternoon, when I was at the CSEA conference, Mr. Mendez initiated a conversation with me. During that conversation, he told me what he has now actually put in writing and had our council put into the record, that our meeting today was problematic because he did not believe that it was the subject matter jurisdiction of the board that we would be discussing the CSEA text message that had been sent out. By making this admission that he believes it is improper for the board to consider this matter, he clearly is admitting that he knows it's not a Brown Act violation, given that a requirement of the Brown Act is that when you get together, you must be speaking on a matter within the subject matter jurisdiction of the board. When one looks at Board Policy 9000, it sets forth the role of the board. It talks about setting direction for the district, employing a superintendent, establishing an effective and efficient organizational structure, providing safe facilities, supporting an instructional program, the development and adoption of policies, supporting academic expectations, adopting curriculum and instructional materials, setting budget priorities, adopting the budget, setting parameters for negotiations, providing community leadership and advocacy regarding the district's educational program and public education in order to build support within the local community. And of course, there is 9322. Now, the sequence of events were that CSEA sent an email, a text message on October 8. I reached out to Mr. Segrist on October 9, and on October 10, there was a Zoom meeting. After the Zoom meeting, I sent an email to Mr. Segrist, which I did ask to be part of the agenda and should be part of the agenda with respect to requesting an action. Now, I respect and honor the right of CSEA and any other individual to express their personal opinion about whatever they perceive any of us to have as our values and to have as who we are as people. By the same token, I would ask that they respect my right to be able to respond to those attacks that are very personal and challenge character and challenge our commitment to our community. And so in light of the text message that had been sent by CSEA, I did request that they send a message based on falsehoods, in my opinion, falsehoods that have been contained in their text messages. At this point, I won't go into those because we may be talking about those later. But what I do ask is, in light of the action that we are going to take today to quote-unquote cure or correct, that the complainant in this matter live up to his word, that once this is done, that this will be put all behind us. And in fact, in an acknowledgement of the fact that he understands that in fact there was no Brown Act violation. So I do urge my fellow board members for us to take this action in the interest of moving forward and focusing on our interest of doing the business of the board. Thank you.
Thank you. Trustee Rodriguez Mesa. Trustee Castañeda. Castañeda Calleros.
Thank you, Trustee Controla. I'll keep my comments brief because most of the comments I've prepared tonight I think are better served under 6.02 and 7.01. And I join Trustee Rodriguez-Moise's comments. I don't have too much to add to it. She has already articulately expressed tonight. I will say this though regarding item 1. An integral part of any response to the November 8th, 2024 complaint letter is to explain why the October 10th conversation took place and the role the October 8th message played in this October 10th conversation. The board has agendized items tonight under guidance from board counsel to provide a curative response to the complaint within the 30-day period prescribed in the law. And for the record, I am interested in joining my colleagues in providing a curative response with tonight's meeting. And I believe it is very important to have a focused discussion on the points on our agenda tonight and a discussion that addresses each of our items and provides context, when appropriate, to understand the dynamics at work that shaped the October 10th conversation. Thank you very much.
Thank you. As for me, same thing. I believe we didn't go in with any intent, nor did we break the Brown Act, do a Brown Act violation. I do want to continue and support the idea of doing a creative response, and that's where I would say the rest of my comments for. All right, thank you. All right, we would go ahead to 6.02.
Can we get guidance from council? Do we need to make a motion?
I think it's helpful, since it's a separate agenda item,
Okay.
if the board is choosing to take action to cure or correct, that a motion be made to do so, which would then take you to the next steps on the proposed agenda.
I'd be happy to. If Acting President Controlla, if it's appropriate, I'd like to move to I'd like to move to provide a curative response tonight, given our discussion during 6.01. Thank you.
Thank you. So we have a motion. Do we have a second?
I will second that.
All those in favor?
Aye.
Aye.
Okay, then we move on to item 6.02, the deliberation regarding October 8th, 2024 joint CSEA trustee Mendez message, October 10th meeting with CSEA.
Madam President, if I could take a point of privilege, even though I'm not entitled to any point, I'm not a member of this board. A couple of items also I think helpful, if I could, just kind of a reminder of fundamentals. One is pursuant to the Roberts rules, and it's again not a reflection on any particular board member here, and I've seen sort of this rule more in the exception than the adherence to it, but I think it'd be helpful to the extent possible, set a good example moving forward. Look to avoid referring to other trustees by name, if you can. You can refer to them by their title. I know that makes it a little complicated, but that's technically what Robert's rule says, and technically the board has adopted those rules. Some of the provisions in that Robert's rules also talking about addressing the measure, not the person, so kind of addressing the conduct, not necessarily the person, the actions rather than the individual themselves in a personal matter. Be mindful of anything, not that a personal attack is within the purview of what this board or these present trustees would do, but all those things are talked about in Robert's rules. The other thing here is that subject matter is pretty unique in that it relates to activities that were happening around the time of an election. So always be mindful that no district resources, including a meeting like this, should be used for purposes of campaigning. Now, campaigning means advocating for either a candidate or a position, not talking about elections and things like that, but just I think helpful to always consider those things. The board, my job is to keep everyone in the focus on doing their jobs to run schools for students and not have to deal with distractions. And so hopefully I wasn't out of line by reminding you of those things, but I think they may be helpful here. Keep those things in mind as you proceed.
Thank you.
Thank you.
We appreciate that. So in terms of the message that was sent out by the president of our board, I was very interested in learning about the CSCA's process of approving a message from any board member. I was not in the know understanding at the time, and so one of the questions that I had for Mr. Segrist was in terms of how the process takes place. Partly because I was very interested in having a response to the message that was sent out. I felt that the message was incorrect, that it was divisive, and that created a us versus them ideology, which is very opposing to what we're trying to create here as a governing board, including, we have been part of a process where we're trying to bring people to be on the same alignment in terms of really supporting our students. And then we see a message that is very personal, that is, again, very divisive. I was concerned about the message that had gone out, especially to all the CSCA membership, because it talked about, not being able, particularly, I think it was a little bit and very personal, and it hurt me emotionally because it basically was saying that I was not somebody that could represent my working class community, which is Area 3. And I had approached president of the board in terms of that strong message, which is very wrong in terms of my own personality, in terms of the work that I've been doing for decades to support underserved students, whom a lot of them are first generation college potentials. And it really felt like it was challenging my integrity as an individual, as a professional. How can I not support a working class or identify with the working class community when I come from a working class family? Having parents that were blue-collar workers working in factories. My father, my biological father, was a farm worker. And even geographically erroneous because it talked about, us being part of the hills. When I actually live in Santa Fe Springs in the community, one of the communities that I represent. And again, the message from the board president was divisive in that it really outlined 3 of us versus the other 2 on our dyad. And so my interest was in finding out how we can respond to such allegations. And in that process, because I always think that it's very important to talk, firsthand to the individual that makes the statements. I did speak to the president of the board, and he said to me clearly twice that these were his opinions. And although I respect that, the opinions that he formulated and as part of that statement were not based on facts. And so, but he very clearly said, it's my opinion, it's my opinion. So we might have all sorts of opinions, but when we were saying something that is not correct, it's then no longer an opinion, it's then a lie. And so, again, I was just interested in finding out what the CSA process would be so that we could also have that opportunity to respond and to also reach out to the CSA membership that received the initial statement by our board president. And so with that, I will open up to my colleagues for any additional statements.
Sure. Thank you so much. It is unfortunate that our CSEA partners who met with us that day on the Zoom are not here. I am confident that they will confirm the information that we are providing. The purpose of the meeting was, in fact, to discuss the text message that had gone out, and we expressed our respect to CSEA for their ability to endorse candidates of their choice and to send out whatever political material they wanted on behalf of their chosen candidate. However, the text message was hurtful and made assertions and statements that certainly I felt were untrue. And I also asked questions about what was the process that CSEA used to vet the truthfulness of the statements that were contained in the text that had been sent out. My recollection is that we were told that the executive committee had in fact reviewed the text message and approved it. I also wanted to clear some of the falsehoods that had been contained in the text message. And the text message, in essence, said that the board is split by social class. All of us come from working class backgrounds. Those of you who have spent any time with me know that my mother and my grandmother and my aunts were all farm workers. I worked the field myself until I was in 9th grade. And so to have a statement made regarding the elites and social class and working class, and a message being sent that created an inference that therefore 3 of us were not responsive or caring to the struggles of working families was very hurtful. I was also very concerned and expressed concern about the fact that we were in essence titled anti-union in the sense of how the message was sent. I asked the CSEA representatives whether they were aware that I had been endorsed by the LA County Federation of Labor, that in fact CSEA had endorsed me 2 years before. And so I couldn't understand why they would allow a message to go out that would characterize either me or the 3 of us as anti-union. I know that the CSEA representatives did not understand why we thought that it was their letter. What I shared with them was that from the text message I had seen, it looked like it was in fact from the CSEA. What they indicated was that there's this action network system that CSEA uses to communicate with its members, and that therefore when it goes out, it looks like it's on their letterhead, but it's just really sort of a text message. And so that was what raised the concern, was that, wow, I understand if this is Mr. Mendez's, the board president's opinion of the 3 of us, but I did not realize that that was CSEA's opinion. I did request at that meeting that a communication be sent out that had a response from the 3 of us, that they would also then circulate to their membership via the same means that they had initiated the circulation of the first text message. I will also add that a couple of days later, I also asked, well, how long would it take you, that is to CSEA, to consider our request? We were told that probably until the following Monday. So that was the meeting, I believe, was on a Wednesday. And so we said, no problem. There were no efforts to intimidate, to bully, In fact, it ended on a positive note with everyone understanding the different perspectives that we were all sharing. And so any assertions that have been made that we have bullied or intimidated anyone during that meeting is completely untrue. On Friday afternoon, after we had already provided the request to circulate our message, I did receive a call from Mr. Segrist and Ms. Zaragoza, in which they thanked me for my professionalism and kindness, and also that of Ms. Canchola and Dr. Casamira Calleros, in terms of how we had approached this issue, and to let me know that the CSEA Executive Board had decided to go ahead and circulate the message that we had sent to them for circulation. So I want to say that that is what happened at that meeting. It was a discussion about respect. It was a discussion about unity. It was a discussion about understanding, and it was a discussion about moving forward. There was no bullying, there was no intimidation, there was no anti-union animus. It was in fact about trying to talk about what we perceive to be falsehoods and CSEA responding to those concerns. Thank you.
Thank you.
If I may.
Yes, Trustee Casimira Calleros.
Well, thank you very much. I'd like to begin by making reference to the Brown Act, which will help be a nice segue into my comments on this topic. And so the part of the Brown Act I'd like to read, I have it here. A section of the Ralph M. Brown Act reads, "The people of the state do not yield their sovereignty to the agencies which serve them. The people insist on remaining informed so that they retain control over the instruments they have created." That's from Chapter 9, Sections 54,950 to 54,963. I entered the October 10th conversation in the spirit of keeping the people of our district properly informed, not misinformed. And I entered the October 10th conversation to prevent the October 8th communication from forming a dangerous precedent that could encourage present or future trustees from using public resources for political ends. And that is a good segue for my three concerns that served as an impetus for my joining this conversation on October the 10th. The first concern has to do with what appears to be a violation of BP 4119. The sending of the October 8th message, the use of the CSEA header, and the receipt of this message by staff members in their district email boxes appears to violate BP 4119, which states the following. 4119 prohibits the use of district funds, services, supplies, or equipment to urge the passage or defeat of any ballot measure or candidate, including any candidate for election, the Whittier Union High School District Board of Trustees. And that's also a citation of Education Code 7054. It also prohibits dissemination of political campaign materials through the district's mail service, email, or staff mailboxes. And so that was my primary concern. It became important for myself and for my colleagues to speak up in light of this apparent board policy violation. In the days after the October 8th message was sent, I was approached by members of the community from trustee areas 1 and 2 and 3, who were all upset by the content and tone of this text message. Like my colleagues, I also have working class roots. Both my mother and father worked working class jobs until about the time I was in high school. My father was a laborer with the gas company, Southern California Gas Company, and my mom was clerical support for a comptometer firm in Montebello for many years before joining with UPS. Both of them are very proud of their roots. And so the second problem is the October 8th text message contained language that was divisive in tone. Using this type of language runs contrary to the governance standards and governance norms that we agreed to as a board and that we adopted in our governance manual earlier this year, including but not limited to being collaborative, withholding judgment, being civil, being respectful. These norms were not maintained in language of this message on October the 8th. And the third concern I have is the timing of the message. On the very same night, we as a board were trying to begin the negotiations period in a collaborative spirit. That very same night, and maybe almost at the very same time, this message was being disseminated. And we were in this room trying to build good nature and a collaborative spirit to be able to sustain us throughout the negotiations period until the spring. And the timing of this message could have sabotaged our collaborative efforts between CSEA and members of this board. I will not comment on the intention of the letters authored, or excuse me, the messages authored, but I will say that being collaborative was one of the 3 promises that was made the night the complainant or / board president became board president in December of last year. That concludes my comments for now. Thank you very much.
Thank you, Dr. Castañeda Cayeros. So we would move forward to the new business. It's been,
May I ask a clarifying question? Council, do we need a special motion as we wrap up item 6.02?
Let me, if I may, ask the present trustees whether it's your understanding, having been present at the reference meeting on the 10th of October, whether today's discussion included essentially all the topics and subject matters of that meeting. Would everyone agree to that? Or does everyone agree that essentially what's happened today addresses all the material aspects of any conversation that occurred on that date?
yes.
Actually, I'd like to amend my original comments to be able to more properly reflect a few things that have not been shared already,
Okay.
if I may.
I think that would be advisable, and at that point, I don't think any formal action needs to be taken because the board will have taken action by having deliberated, discussed it in public at an agenda meeting.
Thank you.
And I'll be brief because I believe my colleagues have already expressed this point about the conversation on October the 10th being very civil and very respectful. And at no point did anyone express any feelings to me that they were intimidated or coerced. In fact, at one point during the conversation, Ms. Zaragoza expressed regret that this had happened and was hopeful that this would never happen again. And she didn't have to say that, but I'm very glad she did, and was also quick to reflect upon our previous endorsements that have been received by CSEA, and her and Mr. Segrist were very respectful of recognizing my good relationship with CSEA over a period of my 14 years on the board. So I just wanted to offer those thoughts in addition to what's already been shared tonight. Thank you.
Trustee Rodriguez Moisa, would you like to add anything else?
I would affirm that what we have shared here tonight is what the subject matter was at the meeting we had, the Zoom on October 10th.
And in that respect, that's really the only action to be taken is whatever deliberation happened there and conducted here tonight pursuant to the published agenda.
Thank you. So can we move on to 7.01?
Yes.
Okay, so we would like to consider the affirmation of the October 10th, 2024 response as part of new business.
I think I'll start on this one. I believe there's an attachment to the agenda item that is an October 10, 2024 email sent at 2:06 p.m. From my personal email, and it was to Mr. Segrist, Mr. Is it Emerly? And Ms. Zaragoza, with a copy to trustees Castañeda Cayeros and Ms. Cachola to their personal emails. This is an email that I sent on behalf of the three of us that reflects the request that they send a communication to the membership with our response to the text message that had been sent out a few days before. The email, which obviously is now a public record and attached to the agenda, describes the reasons for our request, primarily that it contained falsehoods, it was divisive, it was hurtful, and that we wanted to ensure that given that they had sent out the initial email that we felt was disparaging of us personally and our character, that we are able to send the attached message. The attached message, I'm going to read it into the record, is the following. Dear Whittier Union HSD CSEA Chapter 42 members, that's the same title I believe that the original text had. It has come to our attention that a message was sent to CSEA members on Tuesday evening on behalf of a member of the board. We write briefly to respond to several of the issues that were raised. During our time of service on the board, we have worked very hard to exemplify the best of our community and to model the behavior we expect of our students. We all come from humble backgrounds with either farm worker or working class family backgrounds. If you know us, you know that we have had success in our fields and remain grounded by our life experiences as the children or grandchildren of immigrants and overcoming barriers. We recognize very well that without the hard work and effort from CSEA members, the success of this district would not be possible. We, like many of you, share the same backgrounds as our Whittier Union High School District students. What we also have in common is our shared goal of providing the best educational experience possible for all Whittier Union High School District students, while providing for the people and the staff that make that experience possible. We want to state clearly that attempts to divide us is not constructive towards those goals and is not reflective of our values. Please know that regardless of the outcome of the upcoming election, we will always have your back. We are not only champions for our students and families, but you as well. Sincerely, Dr. Russell Castaneda Calleros, Ms. Josefina Canchola, and Ms. Irma Rodriguez-Moisa. And I would ask our board to affirm the request that was sent via the email along with the attached message that I've just read. So I would make that motion.
So we have a motion, second.
I'll second the motion.
All those in favor?
Can we have discussion?
Discussion, sorry.
I just wanted to add really quickly before we call the question, how important it was not only to set the record straight. For me, that was important to me, but it was secondary compared to my investment in wanting to make sure that we maintain a healthy relationship between the CSEA membership and the e-board and the Board of Trustees. And that's why we're going through a very painstaking process trying to make sure that we cure whatever needs to be cured tonight, and so we can get on with the business of the district and continue to take steps to make sure that we invest in this relationship. And I hope my colleagues can echo are valuing this relationship to the point where we took the time to have this conversation on October the 10th because we so value this relationship and being able to continue communication in a way that's respectful and civil, regardless of what divisive communication has originated. Thank you.
I would like to underline the same thing in terms of the value and the importance of a good working relationship with CSEA, and particularly because some of us are going to be here for a few more years, and relationship is what really builds Whittier Union High School District and how we can better serve our students. And to be quite honest, I think it was also essential for us to continue working with our board president because he is part of the DIAD. And so in setting the record straight, I think we wanted to make sure that the CSEA did get two sides to this perspective. And again, underlining how much it did hurt, because to read something like that when we know that, not only in our personal histories do we represent the communities that we are all voted in to be here and represented in the Dyad, but also the historical work that we've all done as professionals and volunteers in our community. And so, so again, all of these conversations, this conversation took place in good faith and really trying to refocus on the working relationships and just setting the record straight. So,
I'll call a question.
Do you want me to do a roll call?
yes,
Okay. Trustee Castaneda Gallegos?
Aye.
Trustee Rodriguez Moisa?
Yes?
Trustee Canchola?
aye.
Couple more items on this provision and in general. The Brown Act provides for certain notifications or communications to be made to a complaining party. In this circumstance, because the actions at issue involve only a single defined past event, you would be falling squarely within the provisions of the Ed Code section, the Government Code section 54960.1. That provision provides that upon an action to cure or correct within 30 days, the district also inform the complaining party, and that can be done by a correspondence from council that I would send this evening. There are additional provisions of the code that address a request made by a complaining party that a local legislative body cease and desist from further violations of the code. That provision was not addressed. I reviewed the complaint of November 8th, and no request to cease and desist future behavior was made. So it would be my understanding that those triggers of the code were not triggered. But the board has some options. One is if it wants to see the proposed letter or letter I will send informing the board president, a complaining party of the action taken tonight. I can share that now if the board wants to see it. You don't have to see it, but I do want the board to know we will be providing a letter informing the complaining party of the action taken tonight. Second part is if the board wants to sort of go with a belt and suspenders approach, there's additional language set forth in the other section of the code that could be added to the letter, which again, I think in the interest of the present trustees having full input on any action taken, I can also share and we can I can take direction from you as specific as you like to give. Did that make sense?
Not really.
Before you go any further, council, I do have a question. You mentioned the phrase belt and suspenders, additional language. What is the nature of additional language you're referring to on top of the standard letter?
So, the only language provided in the code under section 54960.1 says, within 30 days of receipt of the demand, the legislative party shall cure or correct the challenged action and inform the demanding party in writing of its actions to cure or correct, or inform the demanding party in writing of its decision not to cure or correct. So the standard letter we would send would say this letter is to inform you that the board took the following action, cure and correct violations, and we will attach the complaint. So that's what I call the simple, straightforward approach. Section 54960.2, which is triggered again when there has been submitted a cease and desist letter by the complaining party, which again, I would not understand this provision to so do. But it provides specific language that includes this. In order to avoid unnecessary litigation and without admitting any violation of the Ralph M. Brown Act, the Whittier Union, in this case, Union High School District Board of Trustees, are hereby unconditionally commits that it will cease, desist from, and not repeat the challenge past action as described above. And the description would be, again, we would incorporate the letter. And the standard process would be we incorporate the letter and say the allegation was the Zoom meeting on October 10, the Zoom meeting on October 10 should not have been conducted or should have been agendized. It's essentially the allegation. So that would be referred to.
I see.
The reason to do that is just because you would unequivocally have foreclosed any ability to bring a lawsuit based on the allegations. These things are built into the code. It's the policy of the Brown Act to encourage cure and correct action as has been taken tonight. And the code specifically provides that any cure or correct action cannot be construed or used as evidence of a violation of the Brown Act. So the policy of the Act is very clearly within its terms to encourage the kind of action the board is taking tonight. This additional provision about cease and desist essentially acts to unequivocally bar a lawsuit of any kind. But again, it hasn't been triggered, so it's really an option of the board.
Okay, thank you. I have a follow-up question, but I'm gonna defer to
No,
my
because
colleague.
go ahead and do your follow-up.
Okay, so my follow-up is, counsel, given what you know about the situation, and given what you know about the complaining party, and given what you heard tonight during the public comment of the complaining party, what would be your recommendation between options 1 and 2?
Certainly, option 1 has to be followed, and that is, I drafted and just forwarded, these are the terms of option 1 right here, with some additional language I just included based on the board's, or the present trustee membership of the board's description of what occurred on October 10th.
I think there might be a typo.
I have a couple of suggestions too.
Yeah.
Are we going to wordsmith it here in public, or you just want our comments and then you'll finalize it?
Well, you got to tell me what to change, so to speak, and we can finalize it. If you want to wordsmith it, we can do that, but either way, if there's some sentiment you would want expressed, it's not in there, now would be the time.
Okay.
Yeah.
Trustee Lisa?
What I would change is in the third paragraph. It says, even so, you see that, in an abundance of caution and in the interest of erring on the side of absolute transparency, you see that? I would prefer that say, even so, in an abundance of caution, and to ensure the public confidence that there was no district business discussed, comma, the board conducted the December 9 meeting as referenced.
I want to make sure that that's the sentiment of all three before I make the change.
I totally agree. That's why I suggested it.
I affirm that language.
Can you read it one more time, the way that you have?
Did you write it down, Terrence, or you want me to say it?
You should say it again. I wrote it down, but I think you should say it.
Even so, comma, in an abundance of caution, and to provide the public confidence that the board did not discuss subject matters within its jurisdiction, comma, it conducted the December 9 meeting as referenced.
Got to jurisdiction and
And delete all that right there.
delete to this.
Until-
Yeah, right there, yep.
Mhm. In your first iteration, oh, sorry, I'm speaking out of turn.
Dr.
I don't know if I had a different iteration before, so.
Thank you for recognizing me. So trustee Rodriguez-Moisa, I think in your first iteration, you had ensure public confidence. I liked that.
Ensure, it's supposed to provide,
Mhm.
Yeah.
and to ensure the public confidence.
Thank you.
E-N or S-I-N?
Ian.
Thank you.
And is that the end of the Brown? Okay.
And that other reference is a standard reference that would be included. It is the provision that indicates the action taken is
Great.
not to be construed or
So this is option one.
Correct. The only thing would be additional to this, I just sent some language, this notion of cease and desist. So it's a belt and suspenders in the sense of the way the code reads is if you have that unequivocal language, it essentially is an automatic dismissal should a lawsuit be filed. So part of the issue is there going to be a lawsuit filed? Or, what's the likelihood of a lawsuit being filed? So it would be along the lines of this board's abundance of caution to ensure the public confidence, and an abundance of caution to forestall any litigation. I would recommend the additional language saying essentially we would not do the Zoom meeting again. Not that you have any likelihood to do so, it just fits into the magic words of the code. But you don't have to in the sense of, it's not, that obligation has not been triggered. So what I'm telling you is in an abundance of caution of legal counsel, that is what I call as ironclad a defense and grounds for a demur dismissal, which means we attach request by judicial notice, the letter with that language, and if the code is followed per its terms, the lawsuit should be automatically
I would
rejected.
like to open it to my fellow trustees for the second portion.
Thank you. If I may.
There's some magic words you should maybe look at too. I don't know if I just emailed a second set of language to you. Because it uses the word cease, desist, and not again. So to the extent you would like to modify that based on the fact that there was really no evidence of a likelihood of it occurring again, there was no request to cease and desist. It's also well within your discretion to say, hey, I think we don't need the suspenders here, the belt's plenty. But I always advise as conservatively as possible, and we wouldn't have to come back to the extent you're okay with the language.
Thank you. Counsel, are there any drawbacks to adding that language in option 2, the cease and desist language?
I would say it arguably creates an implication that there was a possibility that it would occur. It just kind of creates an inference that may not otherwise be there. But again, it's still subject to the same judicial limitation and statutory limitation that any corrective action taken is not to be construed as an admission of a past violation. So legally, no, there's no implication. But rhetorically, it could be read as, well, why would you do that if there was never a likelihood it would occur again? So really the reason you do it is because the code allows you to, and it's an additional means of defense to avoid litigation, which is this whole process built into the act. It really does encourage parties to do these measures.
Thank you.
And maybe it didn't go. I'm gonna send it.
My initial inclination is to go with option 1. I think with option 2, I haven't seen the language. I think that if there is litigation commenced, that we've got our defense that it wasn't a Brown Act violation. And I am concerned that by adding it, you create implications of wrongdoing. So it kind of undermines the first part of the letter. But I haven't seen the language, but that's my initial inclination.
Trying to send it as we speak.
Should we take a 5-minute recess? for Mr. Gallagher?
You can. I won't need 5 minutes, but absolutely 5 minutes.
Well, since you're gonna go, I think we lose our quorum once Dr. Seneca goes.
I mean, it's okay,
So
but
let's go do that.
5 minute
Let's take
recess.
5 minutes.
I second the motion if it needs a second.
I gotta use the restroom too.
he just can provide direction, but, maybe, depending on what happens, we can. It's the same language. So you could, I mean, once we figure out option one, then do a motion directing that. I'll ask one of the board members to make a motion to direct council to send notice. Well, I mean,
It's a totally different letter.
yeah, why do it so? To go, it's just, it's showing assent. Here, we can just look at it. This would be added to the other.
November. Yeah. Go to high school.
First of all, hit copy.
Okay, should we go ahead then?
Myra? Myra, there's water bottles back there if you want.
I'm sorry?
There's water bottles back there.
Oh, thank you.
Okay.
Off topic, we were speaking that.
So you're asking me to put it into the prior
The
document.
girl that, one of the fireworks fell and broke during, one of the
Oh.
November, bus traffic meetings, service classes. We were wondering if they ever, if the girl ever got paid or compensated for her hard work.
Oh, for that one?
Yeah, I felt so sad.
You know what, we gave them, those, at least once a month, those friends drop some breaks. And we give that to our teachers so they could give them, the kids are refraining them somehow. So, I know, just,
I would go. There would be more language in it. But I keep thinking, I can see this. Not sure what's up. Did it work? Here, I can, by the time you do that, I can right click it in there.
You want to do it? You want to do it?
Either way. Either way, it'll.
Working with this.
Right.
Are we ready to resume?
Yes.
Okay. Would you like to read it out to us or we can?
So this is the language here. You'll see it uses these words, cease and desist, avoid unnecessary litigation. So that those words are taken in the words unconditionally commit. So the board would have to, if it's inclined to provide this additional notice, have to, in this meeting, vote to unconditionally commit to, and that's the second paragraph, cease, desist from, and not repeat the challenge action as described in the November 8th letter, and which would be, it's the same language as described above. That language where it got cut off just had seemed, I think, happened in the cut and paste, but it basically, it's the same language. As noted, unconditional commitment is not evidence. So the
Okay.
Same language essentially that I read straight from the code.
Okay.
The considerations in regard to sending it are, as we've already discussed, and I think as Trustee Rodriguez pointed out, not necessarily applicable here, given there's been no cease and desist.
Any
Request.
discussion in terms of our options?
So it's really, if you want to be ultra conservative, you include this. If you're okay, with the language that you provided certainly confirms the cure and correct. We will be informing of that action, so that aspect of the code will have been met. You also have the option to do this later, should a cease and desist letter be submitted. The current position would be, since there's no demand for cease and desist, there's been no trigger that would then obligate or bring into play this provision yet at this time. So really the only reason to do it now is to be proactive, avoid the need for further proceedings on this issue.
Trustee Rodriguez Mendoza.
I would like to wordsmith this.
You absolutely
but-
can.
But I want to make sure that in my effort to wordsmith, it doesn't undermine what your goal is. Because I will share with you that based on how this is written, I would not vote in favor of it. But I am interested in the sentiment that you want us to express. So if you'll indulge me for a moment in reading how I would like it to read if possible.
Absolutely, if you may indulge me before you do very quickly, so that the straight language from the code says, the board, I should say the legislative body, et cetera, provide a response, quote, in substantially the following form with that language in it. So it doesn't say this exact language. So as long as the proposed changes would be substantially in the form.
I will let you be the judge of that, okay? So I think I would be more comfortable if it said, to further acknowledge the district's commitment to transparency and desire to avoid unnecessary litigation, the governing board at the December 9, 2024 meeting unconditionally committed that 3 or more trustees would not participate in a Zoom video conference with or without union leaders in attendance concerning matters that are within the subject matter jurisdiction. This is super long, except as previously agendized at a meeting open to the public. Oh, where did I have the cease and desist? Hold on.
That is the next paragraph.
No, I know, I don't, that's the paragraph that I don't want in there, but I was trying to work that into the first paragraph. It's hard because I'm a person who has to write things out. To further acknowledge, it's just going to be manager for the litigation of the supervisor, unconditionally committed that dash I kind of want to combine the two. I don't like having the separate paragraph is what I'm trying to convey. I don't have a problem with that first paragraph. I think that first paragraph is consistent with our previous message. But it seems that you need a cease and desist, or because you already have unnecessarily unconditional committed up above. Do you see that?
Correct.
And so it's the cease and desist piece that's missing from that first paragraph, and I think that's where I wanted it to be worked in, if my fellow trustees were open to it. Otherwise, I would probably, because I'm okay with that first paragraph. It's just, it's the last paragraph that I believe is inconsistent. Governing board at the December 19th meeting unconditionally committed and agreed So let's put it this way, if I can't work it in right now, the only part I would personally be comfortable with is the first paragraph. I think that's consistent with our message. The second paragraph, I believe, undermines our original message.
Yeah, and that's not a problem in the sense of the way the code works is, should the cease and desist demand be made, you can send a response to that. At this point, to the extent a lawsuit was filed, the district's position would be it's premature because no cease and desist letter was provided.
So for clarification purposes, if that was requested, will we have an opportunity to look at that additional version of the?
Absolutely. In other words, the code also provides that you can provide this response later than 30 days from the initial response, but it has different provisions for dealing with attorney's fees, costs, things like that. So it has a slightly different outcome, but materially under your circumstances, because there really wasn't a demand for a cease and desist, you will have the opportunity to address this later. But you'll just have to do it in a meeting, you have to add it to an agenda, it'll be more action that would have to be taken.
So,
So I think the action to direct me, if I may, Ms. Rodriguez, is to send a letter. We'll take out that last paragraph and you'll direct me to send the correspondence.
that's my personal preference. Obviously, I've got, I don't know, you all may prefer that we include all of it, but that's my personal sense.
Ms. Controller?
I'm more comfortable with the first version at this moment. Given that the second piece was not outlined in the request. And if need be, then we would come back to it and maybe have a better opportunity to wordsmith it. So do we need a motion, a formal motion, or do we?
Yeah.
I think you're still discussing this option right now.
Yeah, and I've listened carefully to both of you and to council's explanation about the pros and cons of going with option 1 or option 2, and then there's even kind of an option 1.5 that Trustee Rodriguez-Moiza has wordsmithed here. But even looking at 1.5 and thinking about option 2, I still, I'm just wondering if it's just more simple and more clear if we just go with option 1, which does the curative action that's needed tonight.
It certainly complies with the obligation to inform, and that we will do. But I figured let's try to resolve everything we can in the interest of efficiency and not having to revive this. But that'll also be up to the complainant in large part. So what happens following tonight?
Right, and I do appreciate your explanation of option 2 and the benefits of adding cease and desist language to possibly preclude future litigation. But I'm of the mindset at this point in time that no matter what we do with this letter, the complainant may choose to litigate on other topics that were expressed during public comment. So, and that's something that I don't think is going to be stopped by this letter.
And to reiterate, this language is straight from the code and these provisions straight from the code. So you're doing what the government code has essentially presented you the option to take. And so the only further action I would recommend is that the board consider a motion to advise counsel to inform the complainant in the form of the letter that had been discussed here.
Is there any further discussion with my colleagues?
No further
Okay,
discussion.
I'll make the motion. I'd like to move that our counsel, Terrence Gallagher, provide this response to the complainant tonight before midnight.
There's a motion. Is there a second?
Second.
All those in favor?
Aye.
Aye.
Okay, the motion carries.
Any further action?
No.
Okay, I'll move to adjourn.
There's a,
Second.
and a second to adjourn. All those in favor?
Aye.
Okay, it is now 5:45 p.m. Adjourned. Thank you so much.
Thank you for your leadership, for your presence. Thank you, Jack.
You're welcome.